Today, this is the first video I'm making in the series for this one, Section 24 HMA. Section 24 HMA is the Hindu Marriage Act 1955. What does it say? It says maintenance, paternity right, and expenses of proceedings. Wherein any proceeding under this act, it appears to the court that either the wife or the husband, as the case may be, has no independent income sufficient for her or his support and the necessary expenses of the proceeding. It may, on application of the wife or the husband, order the respondent to pay to the petitioner the expenses of the proceeding and monthly during the proceeding, such as some as having regard to petitioner's own income and the income of the respondent, it may seem to the court to be reasonable, provided that the application for the payment of the expenses of the proceeding and such monthly sum during the proceeding shall, as far as possible, be disposed within 60 days from the date of service of notice on the wife or the husband, as the case may be. Further, in subsection 1, what they say is, as far as maintenance, parental right, and expenses of proceedings are concerned, no distinction has been made under Section 24 of the Act relating to right of wife of maintenance preferred under Section 12 or 13 of the Act. Quoting Sandeep Kumar versus State of Jharkhand, AIR 2004, Jharkhand, page number 22. In subsection 2, the divorce proceedings has terminated adversely to his client, but an appeal is pending. Whether the appeal ends in divorce or not, the wife claim of maintenance, qua wife under the definition contained in the expression B to section 125 of the code continues unless parties make adjustments and come to terms regarding the quantum of the right to maintenance. It is clear that mere divorce does not end the right to maintenance. Captain Chandar and versus Veena Kaushal, AIR 1978, Supreme Court, page number 1807. In subsection 3, during the pendency of the divorce proceeding at any point of time, if the wife establishes that she has no sufficient independent income for her support, it is open to her to claim maintenance parental right as per Manokaran versus Devki, AIR 2003, page number 212. In subsection 2 of 2, section 24 entitles not only the wife but also the husband to claim maintenance parental right on showing that he has no independent source of income. However, the husband will have to satisfy the court that either due to physical or mental disability he is handicapped to earn and support his livelihood. Held that since the husband was able-bodied and was not mentally ill, and only because his business had closed down, he could not be granted any maintenance. It is being opposed to spirit of Section 24 of the Act. Kanchan versus Kamalendra, AIR 1993, Bombay High Court, page number 493. General. In subsection 2 of 1, pending an application either under Rule 5 or Order 9 or Rule 9 or Order 9 or Rule 13 or Order 9 or of the CPC, a spouse is entitled to maintain an application under Section 24 of the Hindu Marriage Act 1955. The expression proceedings under the Act appearing in Section 24 cannot be given narrow restrictive meaning. And this is as per the Vinod Kumar Kejriwal versus Usha Vinod Kejriwal, AIR 1993, Bombay, page number 168. In the same subsection 2, as per section 125 1D, has imposed a liability on both the son and the daughter to maintain their father or mother who is unable to maintain himself or herself. Here the quotation of the one case citation is Dr. Vijaya Manohar Parvat versus Keshri O. Rajaram Swai AIR 1987 SC 1100. The direction of the civil court is not a final determination under the Hindu Adoptions and Maintenance Act, but an order pendent like under Section 24 of the Hindu Marriage Act to pay the expenses of the proceeding and monthly during the proceeding, such as sum as having regard to the petitioner's own income and the income of the respondent may seem to the court to be reasonable. Captain Ramesh Chandra versus Veena Kaushal AAR 1978, Supreme Court 1807, page number 1807.